So welcome to our health and human rights module. So this is our health, law, and human rights course. So the purpose of this class is to introduce ourselves to this module. We have already introduced ourselves in the other module that I take, that is the Introduction to Medical Law and Ethics. And for that matter, I presume that we know ourselves. You know me, I also know you, because the same class which is taking this module. Now, what is health and human rights about as a model? It is that aspect of the program we are seeking an exploration of the meeting or the intersection of health and human rights. So if you take health and human rights, what is the sort of a relationship between them? Probably, how does human rights advance issues of health? Or how can health benefit from human rights framework as it were? So these are some of the matters which we want to explore. At the very outset, it is pertinent to know that Wisdom, can you confirm if I am audible? Can I be heard? Can I be heard?
Yes, we can. Yes, we can hear you.
All right. Thank you.
Yes, my lord.
Thank you. Good. So we need to note at the very outset that health is not merely an absence of disease. So in talking about health and human rights, we're not only talking about health understood as absence of disease. No, we are talking about something much bigger than that. Of course, absence of disease is part of issues of health, but we would like to have a healthy situation without having to combat disease, as it were. So, safe living conditions, equitable treatment in healthcare services are all part of what we are interested in as health. Now, for this year, I am making a bit of a change in how I introduce this course. And before we continue with the rest of the introduction of this module, health and human rights, I have noted that one thread which runs through the kind of discourses or discussions which are engaged in as far as this type of model is concerned is right. Right. And very soon, people will be talking about the right to health, right to healthcare, and so on. So I want us to have what we call conceptual clarity. Conceptual clarity in the sense that the word, which is a thread in the various discourses that are had in this particular model, is right. And right, as you and I know, can be used in different contexts, can be used in different situations. No wonder many years ago, a respected scholar called Wesley Newcomb Hufeld, he did a very good scholarly work, and he sought to do conceptual analysis of rights. And Wesley Newcomb Hufeld, writing in the early part of the 20th century, was very much concerned to bring analytical clarity to the concept of legal rights. Why was that necessary? Now, he had observed that rights was often used ambiguously. Ambiguously in the sense that when it is used, it often suggests more than one meaning. And because of its capacity to build multiple meanings, it often conflicts meaningful discussion because of the multiplicity of meanings. Which of the meanings will we be relating to? And that is why he sought to try and clarify this ambiguity. For example, sometimes right is used to mean a legal claim, not a legal claim to something, entitlement. Other times, it rather suggests liberty, liberty as in freedom, if you like. And some occasions too, right is used to connote power. It's used to connote power. For example, will the court say that I have the right to sentence you to imprisonment? Now, if a judge, for example, says that, is he really trying to assert that he has a right? Certainly not. He's actually referring to the fact that he has the power to do that. But the word right will have been used. And that adds to the confusion that Hufeld is drawing attention to. It is also possible for the word right to be used mean immunity. Immunity simply means that no one can change your legal position. So you are immune. In relation to you, if I say that I'm immune, that is to say that you do not have any power to change my legal position or my legal situation, as the case may be. So let's keep that in mind. So in order to overcome this confusion, Hufeld dissected the idea of right into 4 fundamental legal relations. That right should be seen in terms of basic legal relations, and that each of such relations has correlative and opposites. So his work has actually been very useful for a long time in trying to understand legal theory and human rights discourse. And of course, in terms of talking about right to health. And that is my motivation for trying to actually break the ice with you in this course by starting with conversation or having some kind of like a bottle of wine or beer with a Hufeld before we actually have our other discussion. So, what are those four fundamental legal relations that Hufeld talk about? So, first, Hufeld identified one use of the word right in the sense of claim right, okay? Claim right. And he said that if a person has a claim right, then there is a correlation or there's something which corresponds to it to make that possible. And that is a duty. In other words, if I have a claim right to something, then there is a presupposition that another person carries a duty or a burden to enable my claim right to be actualized or concretized. So let's keep that in mind. So the correlation of claim right is duty. And I want us to get this thing very clear because of the nature of this health and human rights that we are going to be discussing, so that when we are using the language of maybe the right to health or using the language right, we should have that clarity in our mind as to what exactly we are talking about. Now, the opposite of claim rights is no rights, as it were. No rights. Of course, if I have a claim right over something, then the opposite of that is that as far as that which I have a claim right to, I cannot say that I have no right, if you like, because I have a claim right to that. And the correlative or the corresponding, relation with my claim right is that another person carries the burden or the duty to do something or not to do something for realization of my claim right. So therefore, if you cannot locate a duty bearer, then in Hufeldian sense, we are not talking about claim rights. Then he also identified what we call liberty, or what is also another word is privilege. That if you have privilege over something, right? You have a privilege over something or liberty over something. That is to say that in relation to that which you have the privilege, then no one has a right. No one has, like, if you like, a claim right in relation to that, because you have a liberty or privilege over that. And the opposite of privilege or liberty is duty. If you have privilege or liberty over something, then you cannot bear a duty for that which you have privilege or liberty to do it as you want and so on. How can you actually carry a burden in relation to that? So the opposite of that is you, of course, you do not have like a duty, but then somebody will have like a duty. Somebody else will have like a duty towards what we call like the liberty or the privilege, as it were. Then we also have power. Power to effect a transaction, to effect change in someone's position or circumstances. Now, if you have power, then somebody should be amenable. Somebody should be at the disposal of the exercise of your power. You cannot talk of power if the power cannot be activated or deployed or triggered in a way which will change someone's position or circumstances. So the correlation of power becomes liability. Liability. So the one who bears the liability is the one who is to be affected by the exercise of what? Of the power. Just as the one who bears the duty in relation to the right claim is the one who is supposed to be affected by the assertion or the enjoyment of the right claim or the right claim right, as it were. Now, the opposite of power is disability. If you have power, then in relation to the one which you have power, you do not lack power. If you do not lack power in relation to that, then it means that you have disability. Disability means absence of capacity or absence of power, as it were. So that is opposite. Then we also have immunity. Immunity means that if someone has a power, as it were, it can be exercised. But as far as the one who bears immunity is concerned, the power cannot be exercised to affect him because of the immunity that he bears. And that is why the opposite of the immunity is what? Is disability. Because if I am immune, then what it means is that in respect of it, I'm immune, you are not able to exercise the power. So you are disabled. You lack the power, as it were. And then the opposite is liability, as it were. So right claim and duty. So a right in Hufeldian sense, as we've been endeavoring to explain, exists when another person or institution has a corresponding duty to act or refrain from acting. For instance, if a patient has a right to confidentiality, the healthcare provider has a duty not to disclose medical information without the consent. So the right to confidentiality carries with it the correlative duty of someone who ordinarily is supposed to have access to the information which is protected by reason of the confidentiality. And he is supposed to keep it protected, non-disclosed. So he has a duty not to disclose. If that duty is not carried out, the right to confidentiality will be meaningless, isn't it? So if we are to apply that to health and human rights, the right to health imposes duties on the state to respect, protect, and fulfill that right. So if we are talking about the right to health, then what it means is that there should be a duty bearer. Who is the duty bearer? It should be like the state. Of course, we can debate that, but at the preliminary stage, I think we can have this as a working understanding. Now, what does Hufeld say about privilege or liberty? A privilege or liberty in Hufeldian schema means that a person is free to act in a certain way without having a duty not to act. So the correlative of privilege is another's no right to prevent that act. So if I have a liberty over something, what it means is that you do not have rights to prevent me from doing that which I have the liberty to do, as it were. So maybe in a very crude example, we could say that a doctor has the liberty to choose a medical specialization. Whether you want to be, when you met in a class, somebody said he was learning to become a obstetrician and gynecologist. And today I have a doctor friend who also told me that that is what is coming up. Now, no patient has a right to compel a doctor otherwise, isn't it? So if a doctor has the liberty to choose maybe specialization, maybe, well, I want to be in the pediatrician, or I want to be ophthalmologist or whatever. Yes, it's a mouthful. Or I want to be ENT specialist. I want to be a general surgeon. I want to be an oncologist. Or just name it. So that is the freedom, if you like, to act in a certain way without having a duty not to act. So the patient, for example, no patient will have a right to compel a doctor to do something other than what he or she would like to specialize, as it were. Now, when it comes to health contests, individuals have liberty rights. So look at how we are qualifying. You're not talking about claim right, you're talking about what? Liberty rights. To pursue healthy lifestyles. But these are distinct from claim rights that impose obligation on others. So liberty rights here means that they have the right to, they are free to act in a way which will pursue, let's say, that which will advance their, their health. So they are free to pursue healthy lifestyles. And as you notice, these type of rights do not necessarily impose obligation on others. So, for example, if you like to take your last meal before 6, if you like to avoid sugar, you like to have a regular routine of exercise or walk 30 minutes every day, you like to sleep before 10, and so on and so forth. That is something that you have the liberty, and no one has a right to compel you to do otherwise. But you being able to do that does not necessarily mean that you impose any burden or obligation on anybody. If you don't want to take fizzy drinks, that's your choice. But I don't have any obligation to let that happen for you. And that is why it's not a claim right. It is no privilege or liberty, as it were. Now let's take another dual relation: power and liability. A power is a legal ability to alter legal relations, either one's own or another. And the correlative of power is what? Is another's liability. So, for example, Parliament has the power to enact health legislation, creating rights and duties affecting citizens and healthcare providers. Citizens, in turn, are liable to the effects of such legislation. We remember the imposition of the Restoration Act during the coronavirus. Yes, the government, the parliament, they have the power to make those legislation. And when those legislation were actually made, the citizens were liable to the effect of it. Your freedom of movement of restricted, isn't it? Another one is immunity and disability. And immunity means being protected from another's power to change one's legal situation. So if your legal situation cannot be changed by another exercising power, then you have immunity in that regard. And the correlative is another's disability. So the one who is bereft of power to change your legal situation is said to have a legal disability. I'm not talking about physical disability, but a legal disability. So for example, under constitutional law, individuals have an immunity against retrospective criminal laws. If you take Article 92 of the Constitution, there's a constitutional prohibition against retroactive legislation, no legislation having a retrospective effect. In other words, a constitution does not permit our lawmakers to make a law which, for example, declare something which has already taken place already as criminal. That is not permitted by our constitution, as it were. So, despite the fact that under Article 93 and Article 106 of the Constitution, Parliament has the power to make laws for Ghana. Now, when it comes to retrospective criminal legislation, Parliament is disabled. Parliament lacks power from enacting laws that punish past conduct. So, maybe in health rights framework, we could say that vulnerable population may enjoy immunity from arbitrary denial of essential health services. Probably. Now, how is this, Hufeldian rights analysis relevant to health and human rights discourse? Well, Hofer's schema illuminates or sheds light on the multidimensional nature of the right to health. And it's pertinent that we acquaint ourselves with that multi-perspective of the right to health. For example, the right to health may be seen as a claim right, in which citizens, for example, have a claim against the state to ensure access to essential healthcare services and facilities. In this regard, the state bears the corresponding duty to progressively realize this right as recognized under, for example, Article 12 of the International Covenant on Economic, Social, and Cultural Rights, the ICESSR. And also, if you look at our Constitution Directive Principle of State Policy, if you look at Article 34, Clause 2, similar provision there. So therefore, of course, we are aware of the debate about the justiciability or otherwise of the Directive Principle of State Policy. But the weight of consensus gravitates towards their justiciability or enforceability. So we will suspend that aspect of the discussion until later on when we are discussing some of these substantive topics. Now, right to health can also be framed as a liberty in a certain sense, so that probably could say individuals enjoy liberty to make health-related choices, maybe such as reproductive decisions, or refusing medical treatment may be subject to public interest limitations. So apart from maybe legitimate public interest qualification or limitations, by and large, as part of the individual's right. And later on in medical law, we come across this autonomy and the right to self-determination. As part of the individual's autonomy, he or she should be able to make the necessary choices. And that in that case, the right to health is being seen as liberty in Hufeldian schemata. It may also be seen as power. So the right to health may also be seen as a power, in which case states possess legal power to regulate the health sector. So therefore, when it comes to licensing, you need to be licensed before you can actually practice as a health professional. You need to have your facility licensed. So we have like the HEFRA, the Health Facility Regulatory Authority. You need to be licensed by them so that you meet certain minimum standards before your facility will be allowed to operate as a clinic or as a laboratory or any health providing service, as it were. Again, when it comes to drugs, the state has the power in approving drugs. If you make a drugs and the state has not approved it through its, for example, have the, the Food and Drugs Authority under the Public Health Act of 2012. If the state, for example, has not approved the drug that you have made, it cannot be sold. It cannot be prescribed because the state will need to verify and subject it to safety standards control or review. So in that case, you see that right to health can properly be called power or be framed as power in terms of giving approval to drugs and also managing pandemics when it comes to public health management. Public health issues, we see the power of the state. Of course, such powers must respect the boundaries of human rights and proportionality. Now, can the right to health also be framed as an immunity? So that persons are immune from arbitrary state interference. Then there's a okay, good. Yeah, so the right to health may also be seen as in a sense of immunity. So that persons are immune from arbitrary state interference in their bodily integrity and privacy. In particular, when it comes to, let's say, vaccination and immunization. Vaccinating people, immunizing them, they're introducing something to the person's body. The integrity of that person is going to be compromised in one way or the other. And with the COVID-19 vaccine, for example, a lot of conspiracy theories out there in terms of what it's doing to us and going to do to us. But some of us, we just trust in God, that it's God who is taking care of us, because we don't have the technical capacity to be able to envisage whether, as a matter of truth, those vaccines are really safe. And if you go to the US, if you follow the news, you notice that I think someone has actually sued in relation to one of the I think one of the vaccines was a fresh suit which have been filed in the US by a very millionaire or very big person. And you see the US Secretary of Health, the Minister for Health, his strong views about safety or otherwise of some of these vaccines and some other drugs. And even the president of the greatest country in the world even has his own personal doubts. And all those things will tell you that when it comes to the state subjecting people to compulsory vaccination, immunization, is not a very light matter. So we may want to find out whether people can have immunity, that people can choose that so long as whatever conditions that you are trying to vaccinate me or immunize me against is not infectious, I should be allowed to decide whether I really want to run the risk or not. And you cannot really exercise your power on me. I am immune. So we will later be looking at the Article 18.2 and then of the Constitution and Article 17 of the International Covenant on Civil and Political Rights as we move along. Good. So, in a nutshell, as I said, I deliberately started with Hufeld's analysis as part of our commencement vocabulary building or taxonomy, so that we will be guided in our choice of legal diction when we are discussing issues of health and human rights. As we have noted, Hufeld has actually taught us that the right to health is not monolithic entitlement. It's not just a right claim. Yes, some aspects will really pass as a right claim, having a corresponding or correlative duty bearer. But it's also a complex web of legal relations involving claims, liberties, powers, and immunities. So if we are able to understand these distinctions at the very outset, then we, as a students of health and human rights, will have been empowered to analyze health rights jurisprudence with conceptual precision. We're able to identify who bears the duty, what the duty entails, and what remedies follow upon breach. Those are very important. I'll give you an example. If you call the ambulance and then they tell you that we are sorry, there's no fuel, or we have a flat tire, so you are not able to come. And touch wood, the person that you call the ambulance for example, dies, or his or her condition deteriorates in an irreversible manner, so much so that his quality of life is going to be significantly different from if the ambulance had actually gone on time to pick him or her to the facility to be treated. Now, will you say that your right to health has been violated by the state? Which right did you have? Is it the claim right? In which case you say that the state has a duty to ensure that the ambulance will be in a ready to move condition so that when it is called, it will be able to rush to wherever you are and provide you the requisite care. Is that really the case? Well, these are matters we need to have at the back of our mind as we progress along this course. And you will notice that the quest to realize health or framing health as a human right is not without controversy. Obviously, because of resource implications, if you want to frame health as completely claim rights, as Hufeld has actually clarified. Now, that certainly goes with a duty bearer. And most of the things will require the resources and so on. So those are the matters I want us to keep at the back of our mind. Before we actually get to know the right to health as a whole topic, if you want to read more, you can I will share this material with you. You can read the original article, which was published in the Yale Law Journal. And also Jonathan Mann will also be citing him. Good. So with this initial conceptual clarification, we would like to look at the key thematic areas which are discussed in this model, health and human rights. So first, we will discuss health as a human right. Human rights, as we know, has been with us since time immemorial, but for it to be framed or crystallized in a proper, legally enforceable entitlement, the story goes to post-Second World War with the initial articulation of the Universal Declaration of Human Rights, which was just a bare declaration, and subsequently the International Covenant on Civil and Political Rights, the International Covenant on Constitutional and Cultural Rights in the 60s. We'll talk about that. So, what is the relationship between human rights and public health? Public health often require interventionist measures on the part of the state, which certainly have implication on the liberties of the individual. Maybe as a person, you would like to smoke freely anywhere you want to smoke. You want to even smoke not only marijuana, cocaine, and so many other things. But because of the obvious dangers associated with that, the state may come in through public health regulation to try and define what can be done and what cannot be done. So we'll look at that. And in that respect, we will try and explore how international human rights that have shaped health rights have evolved, as I indicated, going back to the whole story of the emergence of even human rights at the international level and then the regional level, and also our national level. Some of you might have done international human rights law, international human rights, or public international law, or some constitutional law. So you may have some appreciation of that already, which is good. In which case, all that we need to do is to focus that knowledge towards health. So how do we mobilize human rights law in the service of health? Of course, if you haven't learned any of those things, you shouldn't be worried. You're not disadvantaged. We come to teach this course without presupposition of any previous knowledge. So I'm not making assumption that you have studied any particular course before coming here. No. So we try to explain everything. And I appreciate the fact that a good number of you do not have legal background. So please forget about the fact that I'm a judge or anything like that. We are not talking courtroom law, okay? If you are not clear on anything, please feel free and don't be shy. We explain. That is why we are here. We need to understand. So our learning objectives will be to understand the historical development of human rights, explore how human rights frameworks address health issues. When it comes to health, as you know, many dimensions. Preventive health, curative health, health education, and so on and so forth. But in the world of providing health, at whatever level or from whatever perspective, it also has implication for resources. And as we know, resources are finite, meaning that they are limited. We don't have enough resources to be able to take care of everyone. And that is what provoke some of the challenges or the difficulties we have in this particular area. So we will also analyze the key international legal instruments and their relevance to health. And we will proceed to have historical evolution of human rights, what has been the story, and early concept of human rights. So we will talk about those things. So to start with, the concept of human rights has roots in natural law tradition. And you may be asking me, what is natural law? Okay. You don't have to worry about that. Let me explain in a minute. Now, when we say that something is lawful or something is unlawful, lawful or legal means that whatever has happened or whatever is done was done in accordance with law which we know to exist. If it is illegal or unlawful, it means whatever has been done or whatever has been omitted to be done, it's either against a known law or there's no law which supports that, as it were. But the question is that the end of the story? Is it enough for us to be told that yes, this is the law. Or we should also be interested in the moral quality of the law. So Parliament makes a law. Is it enough for us to be told that this law came from Parliament? And we know that under our constitutional system, Parliament is a body clothed with competence or power to make law. So can they make any law at all? That they make a law and say that henceforth, all those whose cars were manufactured before 2020, the cars are not to move again. Are we happy with that? Of course, the law came from Parliament. They have the power to make law. Are we happy with that? Or Parliament makes law and say that nobody should go to church or nobody should go to mosque again. It is an offense. Yes, Parliament has made that law, but are we happy with it? Now, in relation to those matters, in terms of what makes law, there are two schools of thought. One school is called the natural law school. Another school is called the legal positivism. The legal positivists, they take the view that the question of what law is fundamentally different from what law ought to be. And for that matter, all that matters is that the law has been posited or the law has been laid down by the law-making authority as whether it reflects a desirable moral quality or not is a secondary matter. So that is the position of the legal positivism or legal positivists. On the other hand, we have natural law scholars or the natural law school, which holds the view that the question of what the law ought to be is very much related to what the law is. And that you cannot divorce or you cannot separate the two. So the law must reflect certain moral quality. And those principles of morality which should be reflected in the law, those principles are universal, unchangeable, or immutable, and they can be known by the use of our reason or by looking at nature. So that's what we call like the natural law school. So we have, some social contrarians, for example, John Locke, Thomas Hobbes, and so on, who will try and develop those ideas. And during the Enlightenment period, these social contrarians, for example, focus their thinking on what we call natural rights, a right to life, liberty, and property. And they take the view that by virtue of being human beings, before we came to have like the state as an institution for us to be citizens of it, all of us, we were more or less sovereign in our own rights. Whatever we wanted, if we are not lazy and we labor, sweated, we're able to acquire property. So these are matters which are very inalienable, cannot be taken away from us. They're part of us. And if we become part of the state, we try to surrender some of our liberties in return for protection. And the protection should be in respect of protection of our life, protection of our freedom, protection of our property. And if the state is to be worthy of our obedience and allegiance, then the state must do its part of the bargain, like I've explained. And those kind of thinking actually influence the American Declaration of what? Independence. And then the French Declaration of the Rights of Man and of Citizen. When we say that we hold this truth to be self-evident, and so on and so forth. Now, these revolutions, which articulated natural rights under the inspiration of these natural law scholars, mark the first significant effort to legally recognize individual rights. And don't forget that prior to that, we have what they call like the era of absolutism, the kings and so on, the queen, and people more or less live at their pleasure. And no entitlement demands or claims could be made of the states. But with these revolutions, natural rights were asserted and became even more poignant during the Second World War aftermath. As we notice, or we know already, the Second World War came to an end when the atomic bomb was dropped in Nagasaki and Hiroshima, killing about 100,000 people in a matter of a minute. And when the dust settled, we came back to our senses as human beings, recognizing that if you wanted to avoid recurrence of this war, then we need to come together. The UN was formed, and not too long after forming the UN, under the auspices of the UN, the Universal Declaration of Human Rights was actually adopted in 1948, in which fundamental statement was made that all human beings, by reason of being a human being, you're entitled to certain rights. And those rights are to be enjoyed, not because the state have chosen to give them to us, but because we are human beings. They are inherent in us. They are innate to us, as it were. And that actually opened the way for evolution of this human right. So if we look at Article 25, for example, of the Universal Declaration of Human Rights, I mean, that's for which is relevant to health. It's to the effect that it provides recognition for the right to an adequate standard of living, including food, clothing, housing, medical care, and necessary social service. If you read the actual text, that is the substance. And what is worth noting is that Article 25 of the Universal Declaration of Human Rights explicitly ties health to fundamental human rights. In other words, health is seen as a fundamental human right. That is to say that it's not something the state is being nice and giving to us. It's something that all of us are entitled to by reason of our common humanity. Now, that provides significant impetus for any thinking about health and human rights, in the sense that if health is framed as fundamental human right, what it means is that all individuals are to enjoy the conditions necessary for maintaining good health. So that is one good thing about that. Of course, this was expanded in the course of time. So we had the 1966, we had, of course, before the 1966, the ICSR, we've had like the ICCPR, International Covenant on Civil Political Rights. But in terms of no direct articulation of health, we saw that in the International Covenant on Communication and Cultural Rights, which explicitly recognize the right to health. If we look at Article 12 thereof, it guarantees the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. The right of everyone to the enjoyment of the highest attainable standard of physical and mental health. So this ICESCR establishes state obligations to progressively realize this right through policies and programs designed to enhance public health and equitable access to healthcare services. Of course, if you look at the framing of the Article 12 itself, there is that tacit recognition of the fact that the right to health is not completely realized overnight. It is like a continuum, like a scale in which you keep making progress, and legitimately so because of health implication. 3 days ago or so, when we met in the classroom, that was I think Wednesday. I don't know whether it was. I don't think it was yesterday. Was it yesterday that we met? When did you have the class? Was it yesterday or 3 days?
I think 2 days ago.
Okay, the Tuesday. Okay, good. So when we met, I asked the question about the doctor to patient ratio, the World Health Organization. And not only that, so many things. Let's take dialysis machines, for example. Because of our poison environment and our dependence on a lot of these, genetically modified foods and other chemicals and so on and so forth. The doctors will tell us that we overburden our organs, our kidneys, and so on. So a lot of burden of the kidney disease around. And a lot of patients will need dialysis in order to be safe. But you ask yourself, how many dialysis machines do you have in Ghana? I don't think we have up to 1,000 dialysis machine. Doctors, can we have 1,000 or 2,000? Is it correct? Or that's too much of an ambition? Will you say that we have about 1,000 to 2,000 dialysis machines nationwide? Let me hear you. Let's be interactive. I've been talking for a long time. Yes.
So not entirely. So I think the last time a publication of the kind was done by nephrologist Dr. Elliot Turner of, yes, It was about 299.
299. 299.
dialysis machines.
I'm sure this about how many years ago, roughly?
This was as of 2023.
Look at that. So just about 3 years ago or 2 years ago. And if we are even to do 100% increase, or even let's say 200% increase, it will still not be up to 1,000, isn't it? So a population of 30 million plus, and I'm sure that we may have not less than 1 million of the population that, clinically speaking, we need at least 1 or 2 visits of dialysis in a fortnight or weekly or monthly. But they are not there. And that is why the phrase, the highest attainable standard of mental health, and if we look at the general comments, number 12 and so on, we will come to appreciate how the committee elaborating on these provisions have provided some kind of indicators for measuring how well a state is doing with respect to this particular right. Okay, so we still looking at the evolution. Now we have the right to health also in the context of the World Health Organization. World Health Organization, there is something, let me see if I can, there's a booklet which previously I shared with students. So, my internet. This is a Microsoft OneDrive or whatever. If the internet is not working, you can't even access your document. Let's see. Oh, synchronize. Zoom synchronizing. Let's go see to open what is that. Hey, zeros, right? Okay, so this one is open that. Okay. Okay. So actually skip this no wonder, okay. So let me show, okay, let's see this. I have it here. Hey. No, sure. Okay. Good. So we have this document by the World Health Organization. I just want us to have a brief look before we continue. And when they made this publication as contribution towards the UN Decade on Human Rights Education way back 1995, 2004. This is what the Director General at the time, Grohalem Brundtland, said, that the enjoyment of the highest attainable standard of health is one of the fundamental rights of every human being. Yet, millions of people have no access to healthcare or even basic sanitation. Faced with this reality, people living in poverty often feel powerless, unaware of their human rights. They are resigned to the fact that health services are too far or cost too much. The right to health is one of our human rights. Everyone has human rights, children and adults across the world. Yes, those who like cartoons or animations, I will share with you so that you enjoy it. But I want you to look at something. Look at so good, like a boy in my school who no one will play with because everyone says it's crazy. Okay, it's talking about the discrimination. No one should be excluded or called names. You should be respected as you and I. When it comes to stigmatization, maybe STIs and other, infectious diseases. But good. So we've learned from the village health worker that my neighbor was infected with HIV. Then the doctor should have respected his right to privacy. He should not have been discriminated against because he's living with HIV. And no discrimination either because of someone's skin color or religion. And remember, women and men are equal, so we must not discriminate because of a person's sex. So women and men have the same rights all their lives. So that's a way to helping us to see how the right to health is implicated by other human rights. Look at this. Yes, but I want you to pay attention. Yes, but health depends on lots of other things. Depends on lots of other things. Now, you understand that freedom from discrimination and the right to privacy are essential for the right to health, and especially living conditions. The water is dirty in my village, and so we are often ill. So see how access to water has implications for health. The right to health also means healthy living conditions. I see, like water, food, and housing. So issues of water, food, and housing, in a sense, they are all part of right to health. So we'll be talking about what we call the underlying determinants of health. If, for example, you are homeless, you're exposed to the vagaries of the weather and an environment, incessant mosquito attacks here and there, certainly you're not going to be healthy. It's not the case that you were sick, but because we didn't have decent shelter or accommodation. But that's great. But what if I'm ill? How does the right to health help me then? Well, it means that health services should be easy to reach. Then, so having access to health facility becomes part of like the right to health as the child acts. And that where you are cared for should be treated with respect. So it's not only you having access to the facility, but when you go there, how you are managed is also part of it. So don't forget that you can ask questions and expect an answer. You should be listened to because it is what is best for you. That counts. So later on, medical or talk about the right to autonomy, informed consent, and so on. Also, your government should make sure that health services are affordable for everyone. So, affordability, access. That means the right to health costs a lot for government. I'm talking about the resources. Human rights are the first priority in deciding how money should be spent. Government should work with others inside and outside their country. And rich governments should help poor governments. So this is just something on a lighter note, but for us to appreciate how these matters we are talking about really are. So let's come back to our material. Yeah, so the World Health Organization, WHO, has also played a very important role in framing health as a human right. When you look at their booklet, the animated ones, and as we noted, the enjoyment of highest attainable standard of health is certainly a fundamental right of every human being, but the literature also indicate that many people are without access to basic health care, clean water, and sanitation, especially those living in poverty. So sometimes I even ask myself, instead of the government spending resources to build, very sophisticated health facilities, which is good, but I ask myself, if we had clean water for everyone, we made sure that mosquito is controlled so that we've addressed the cause of malaria. We have clean environment so that typhoid and cholera, dysentery, and all that are checked. People are given proper sex education. Maybe reproductive condoms and other things, for example, are even given out. I think it will substantially improve health for the entire or greater part of the population, rather than just investing, huge resources in one facility, which may end up serving not even up to 200 people. So those are some of the things I'd like us to think through as we move along. So the World Health Organization reminds us that the right to health includes both access to timely and appropriate health care, and then the underlying determinants of health, such as access to safe water, food, and housing, as we saw from the booklet that we discussed. Again, empowerment through awareness. People need to be aware of their rights so that they can assert them. And they can also demand better health services. There's also need for accountability. Government and powerful actors must be held responsible for providing healthcare services that are accessible, affordable, and respectful of human dignity. And World Health Organization, for example, in some of the literature will tell us that when people have better understanding of their rights, they are better positioned to advocate for themselves and challenge unfair health systems. And for example, I ask, in Ghana, have we ever had an occasion where government budget is read and people will look at allocation given to health and then begin to say that maybe for the past 10 years or 20 years, if you look at allocation to health compared to allocation to some other sectors, we notice that other sectors are getting more of the national cake than health. And that undermines the right to health for everyone. And that's what they give like the state's pressure to try and upscale the allocation to, let's say, health sector as it were. We don't often hear about that. And all that we're interested in Ghana is just NDC and PAP political discussion, as if that will bring good health to us. Yeah, so health, we are told, is a fundamental human right. So there's a relation between health and the human dignity. So the right to health is very much linked to the concept of human dignity. And human dignity underpins international human rights law. And the point about it is that individuals should be able to access healthcare and live in healthy environments. And that is absolutely crucial for respecting their inherent dignity. And as we saw, a lot of people still live in the extreme poverty. And even in Ghana, if you look at the living conditions, where people sleep and so on, you notice that we still have a lot of things to address. We've talked about non-discrimination in healthcare, and we saw the example, especially the problem of stigmatization, the people getting HIV, or because of name calling or people pointing fingers. Maybe certain treatment will not even be assessed, which will have benefited people. So all those things are part of it. So later on, if we look at the work of Jonathan Mann, he tries to develop the relationship between non-discrimination and human rights, and he actually uses some global case studies to drive home his point. So we have to look at these materials, but we have had what do you call them? We started everything right away, but let's go back and acquaint ourselves with the topics as in the course outline, which we'll be doing. Yeah, so back to we've already started our first topic, but at least as we made some progress. So back to our course outline. Health, law, and human rights is a course which is taught in a seminar format. in the sense that students are supposed to be directed to read material within certain thematic, areas, and they speak to the plenary class. We engage them. So that is the point about the seminar approach to discourse. But that said, as we have noted already, this course actually seeks to explore the interrelationship between population health and human rights, between public health and international human rights, and fundamentally, how can human rights law, human rights doctrine and jurisprudence, how can that be mobilized in service of promoting or advancing health? So that is the basic focus, as it were, of the course. So what are the objectives for us in this course? To develop a multidisciplinary perspective of health and human rights research. So as you notice, this is a course. It is not just only law, okay? It's both law, policy, and also evidence-based. So some of the things are evidence-based. We need to assess available literature and some research findings to buttress certain things. The course will also help students to develop and apply the principle of critical thinking to scientific and other claims, including the ability to identify, question, and challenge assumptions underlying various belief systems, as it were. Of course, the point about master's education is to sharpen and deepen our critical thinking ability. Again, the course will help us to identify and communicate human rights implications for individuals and societies, including diagnosis, treatment, and prevention of various health-related conditions and social policy issues. Of course, just like any properly conceptualized model, the course will also give you some transferable skills, things that you develop as you go through the course, and you can apply it to some other areas, not necessarily only to law or to health and human rights. So those are and that is the point of education, to just shape you in various ways. So in terms of topics that we do, you've done the first topic already, the introduction to the course and history and context of human rights. That's what we'll be discussing at the start. So our next topic will be the core principles of human rights and International Bill of Human Rights. So we take the Universal Declaration of Human Rights, we take the International Covenant on Economic, Social, and Cultural Rights, International Covenant on Civil and Political Rights, and we will be discussing them. So some of the materials that we'll be using are what we have provided over there, especially Jonathan Mann's work, which was published in the Journal of Law, Medicine, and Ethics, the Human Rights Imperative for Public Health. We also look at the other works, other materials we also be shared with you. Now, from there, we will proceed to look at the theoretical and philosophical foundation of right to health. Already, we have had like a teaser by looking at Hufeldian analysis. But beyond that, what are the doctrinal or theoretical difficulties, as well as practical conundrum that impede the development of health as a human right compared to other rights? Why is it theoretically difficult? Or how may the theoretical challenges regarding the development of health as a human right may be mitigated so as to be able to still frame it as a human right? So we look at this from various perspectives. We also move on to our next topic after that, which will be health rights in Ghana. So if we look at our constitutional and statutory context, can we say that health has actually been developed as a right? Can citizens, for example, invoke Article 33 of the Constitution to enforce the right to health, just like they can enforce any other right within the Chapter 5 of the Constitution, Fundamental Human Rights and Freedoms? Can that be done? Or if you look at our emerging legislation on health, can we say that you've really got into that stage? Now we will proceed to look at evaluation of the impact of public health policies and program on human rights. So how various public health policies and programs affect its in relation to health. And here we have Lawrence Gostin, who has done a lot of works in terms of global health, global public health, and so on. So we'll be reading some of his writings. This will take us to the realization of economic, social, and cultural rights. So the right to health. So the right to health, what is the picture as far as the global scene is concerned? We would like to look at some case studies which have been done in various areas. And when we get here, and of course, for some of the topics, there's a book which I let students actually read. I share the areas for them, what they call like the right to health in international law. Don Tobin. I used to have like the PDF and see if I'm able to locate that. Otherwise, if you go to the University of Ghana Library, a copy should be there. We will use that as one of the core tests for some of the things that we will be discussing. Then we look at AIDS policies and practices. What we are told that there has been like some resurgence of HIV, AIDS, because maybe public education went down, so people think that the disease has vanished. and will be having indiscriminate intimacy and so on without protection. And a lot of people are infected. And the sad thing is that it's not written on the forehead of anyone. You only go and get involved with the person and you get infected before you become aware. We also look at the health and humanitarian emergencies, where we have war, natural disasters, and so on, warranting movement of people from areas of danger to safety. There are health issues which come up. How is health also weaponized? There's a risk of weaponization of healthcare in those situations. Then we also look at the protection of human rights of persons with mental illness and other disabilities. Of course, we are doing mental health law, so we will not suffer much when we get here because you have been studying mental health law. And we also look at the torture and the role of health professionals. Torture is also one important site for discussion of health law and human rights. And again, we will zero in on public health emergencies and emerging infectious diseases. So, in a nutshell, this will be the journey that we'll be embarking upon. In terms of topics, we will be giving you materials as we go along and also have a series of presentations, as I told you. So I'd like to find out, Joanna, are there groups which have been formed already? Wisdom?
No, Doc. No, Doc.
Okay.
I have to do that.
Okay. So how many are the students so that we know the groups to form?
We are still compiling the list, but currently it's around 75.
Okay, so let's say that I'm going to hold my fire by next week. We'll know the number so that you know the number of groups to build. Okay, so I will end the class here and take any questions that you may have. Okay, I don't see anything, so have a good night.
Good night.